Is the counsel for appellant present in the courtroom in the first case, Braxton versus Holmes County election canvassing? Okay, in that case, we will take the cases out of order and hear City of Lynn Haven versus Bay County. After the second case this afternoon, which will be, the second case will be the Industrial Blowpipe and Lumberman's Mutual case, we will take a short break, and you're welcome to join us for coffee in the lawyer's lounge to our left. Counsel.
If it pleases the court, my name is David Theoriak. I represent the City of Lynn Haven. With me today is the City Manager, John Lynch, the Mayor, Mayor Kelly, and my associate, Tim Dennis, also the City Attorney, Rob Jackson.
Counsel, would you like to reserve time for rebuttal?
Yes, sir. 5 minutes, Your Honor.
I'll try not to interrupt. You'll need to keep track on the clock in front of you.
I just moved my binder down. I was covering it, so thank you. Good idea. This case involves a challenge by Bay County to a voluntary annexation by the City of Lynn Haven. The Circuit Court quashed the annexation by the City. The City respectfully submits that the Circuit Court departed from the essential requirements on 3 ways. The first manner that the Circuit Court departed from the essential requirements of law pertained to the Circuit Court's incorrect conclusion that the county had standing to contend that the voluntary annexation violated the substantive requirements of the Annexation Act, which is Chapter 171. Even assuming that the county has standing, the Circuit Court also misconstrued the word contiguous, as that term is defined in Chapter 171. And then the Circuit Court lastly improperly reweighed the evidence that was presented during the City Commission meeting on the issue of contiguous.
So, counsel, on the first point, then, I assume it's your argument that the county, in a typical voluntary annexation case such as this, where the county doesn't own property within the voluntarily sought-after annexed area, they're limited in their legal rights to simply go into circuit court and say, well, you didn't file notice in the newspaper, you didn't have a second hearing within, those types of procedural requirements.
Absolutely, Your Honor.
That's not very much play for the county to participate, is it?
It is not. And when I first read the statute pertaining to voluntary annexations, what jumped out at me was there appears to be, in the plain language of the statute, a 2-tier test that the legislature has set forth. And while there may be a policy determination on whether that's good policy or bad policy, that policy determination would be for the Florida legislature to address. Well, when this court reviews, particularly Section 171.081, it appears, and the city respectfully submits, that there's a 3-part test to be able to maintain a challenge to a voluntary annexation. The first part is the entity challenging a party affected? And that term is defined in 171.315, and nobody disputes in this case that the county is a party affected. The rest of 171.081 sets forth a 2-pronged test. It specifically states that a party affected may challenge an annexation based on the fact that the city failed to comply with the procedures. It specifically uses the word procedures. And then the section also continues on to state that a party affected may challenge an annexation on the basis that the city failed to meet the requirements established in the Annexation Act, quote, as they apply to his or her property.
Well, let me ask you this then, counsel. If we accept your interpretation of the statute, I guess your argument is, however the legislature intended it, that's the way they wrote it, the way you're arguing. In this case, then, let me ask you hypothetically to concede, just for the sake of argument, that the property the city sought to annex is not contiguous, just for the sake of a hypothetical. that the water body has, as you put it in your brief, the effect of separating the two parcels. Bay County comes to court to seek to quash the annexation on the basis of 171. The court looks at it and says, yeah, I can see here that's not contiguous. You're trying to annex a piece of property that's separated by a 50-mile wide long water body. But county, you can only come in here to argue procedural requirements, so I'm going to deny the motion. That's the result of your position.
We can come up with a hypothetical that would be exactly as you described, Your Honor. In this case, there was actually a franchise that provided sewer and water that would have had standing to challenge, so the hypothetical that you've set forth would not apply in this case, that if the county didn't have standing, nobody would. There was an entity
Well, I
that
didn't ask if
standing.
anybody else would have standing.
Right.
I'm just asking you, under your
Yes.
analysis, Bay County, subdivision of the state of Florida, cannot come into court and seek to quash a voluntary annexation that is illegal on its face, substantively speaking, simply because they only have the right to challenge a procedural deficiency.
Yes, Your Honor, I agree with that hypothetical, and the basis for agreeing with that is to provide plain meaning to the words and the format of the Annexation Act. For example, if you accept the county's argument that they're a party affected and therefore they have an absolute right to challenge any defect, any alleged defect, whether it's procedure or substantive, then there's no reason for 171.081. All you would need would be the 171.315, which defines party affected. So by accepting that argument, essentially the court would have to say that portion of 171.081 is a nullity. Secondly, the court would have to ignore the distinction between procedure and requirements. In 171.081, it clearly in one place refers to procedures, and it refers to any affected party, or party affected, I keep flipping those two. And in the second place, in the same section, it refers to requirements. And as this court knows, it's a well-founded principle of statutory construction that when the legislature uses a term in one place and a different term in another place, that the intent of the legislature is that there's a distinction to it.
Well, you would acknowledge then, though I assume, though, your position were it to prevail, and which would require this court to write the opinion stating that this is the interpretation of the statute, which hasn't been done yet, according to you. That's a pretty draconian effect on county governments, right?
It would be a draconian effect. It's a policy call, and the legislature could address it in the next session on whether that is the public policy that they desire for dealing with the county's ability to enforce annexations. But as currently written, not only would the court have to do the first two things that we just discussed, but the third thing, the court would have to ignore the part which says requirements apply to his or her property. The city's construction of 171.031 and 171.081 harmonizes those two sections. It acknowledges the legislature's use of different words, procedure versus requirements, and it doesn't ignore the phrase requirements as they apply to his or her property. For the court to hold that the county actually has standing in this case, the court would have to ignore the requirements, the distinction between procedure and requirements, and fail to harmonize the affected party versus the 171.081. I'd also, I know I'm spending a lot of time on this issue, I'd like to draw the hypothetical or the analogy to a movie ticket. And I was trying to think of, well, how could this make some sense? If you wanted to go to an R-rated movie, you have to be 17 years or older. If you're 17 years or older, that gives you the pool of folks that are entitled to go watch the movie. And you still have another step that you have to take, which is to purchase the ticket. The way the statute is set out, the being a party affected, which everyone concedes that the county is akin to being 17 or older. They're in the pool of eligible folks to bring a lawsuit. But then the county has to ring the bell on one of two issues, either procedure or substantive. And if it's substantive, they have to demonstrate that those substantive requirements as they apply to its property are somehow affected. There's no question that the county in this instance could have raised procedure, but there were no procedural laws. The second departure from the essential requirements of law that the city respectfully submits that the circuit court performed was it did not construe the term contiguous appropriately. The circuit court and the county tend to argue it's size that counts. And there is nothing in the statute that would establish any criteria, any standards, anything at all other than an ad hoc basis when a city goes to circuit court for a circuit court to say, well, it's too big. Essentially, without standards, without criteria, you're going to get into a is to, is not argument, because there are no standards.
How do you interpret the phrase then, if, excuse me for interrupting then, that is in that same statutory subsection referring to other minor geographical separations?
Two ways, Your Honor. First, we don't believe the other minor geographical, I just drew a blank on the word, applies.
The clause.
Right. The clause applies to the body of water. We think with the or and the comma based upon the two cases that doesn't qualify body of water.
What does it mean by or of a similar nature then?
I think it's identifying the fact that a body of water and a water course is a minor geographical feature that would qualify for the ignoring the fact that there is a water body and therefore the land on both sides of the water body is contiguous.
Well, what about the end of the subsection 11? What's the competent substantial evidence that supports a finding that the annexed property could become a, quote, unified whole with the city?
Yes, sir. And I think what you just pointed out as well, Your Honor, supports our contention that that's the test that a circuit court judge should be looking at is there a unified whole with respect to municipal services, and is there something about the body of water that prevents the inhabitants from the annexed property from interacting socially and economically with the city? And the competent substantial evidence that was in the record was set forth from the expert witness retained by the city, that the property was connected to existing city limits by local roads and State Road 77. There's a bridge that goes over the bay that allows the city residents south of the bridge to interact with the annexing property. There's already been 3 other annexations across the water body. Those residents could interact with the residents on the 3 portions of property that have already been annexed. The city can provide such services which the county can. The EMT, first responder, fire rescue, reclaimed water, waste collection, street sweeping services. Those are services that the county doesn't even have the ability to provide. That was unrefuted in the record. And then lastly, Your Honor, the city also can provide the following services in a more economical and timely manner. The city's police department is only 1 mile away, whereas the sheriff's department was 2 miles away. The fire department was 4 miles or 4 minutes away for a response time. The county has a volunteer response or a volunteer fire department that could not quantify a response time. The city's library, for example, is 1 mile away. So there are various examples that the city's expert witness provided saying here are urban services that are available to the folks. They are either available and they're not available in the county, or they're available and they can be done closer and more efficiently than the county.
Counsel, you're down to 3 minutes.
And I'll sum up in 1 minute here, hopefully a little bit quicker. If you accept our argument that it's the effect versus the size, then the other thing that has to be kept in mind is that this is a legislative determination, although it's under certiorari, which is kind of a hybrid, because typically you only have a quasi-judicial act that's reviewed by certiorari. But this is legislative. And it was up for the city commission to review those very factors that we just described on those urban services to make the determination, did they support that it was unified as a whole? And then the circuit court should have provided deference to the legislative act, and the circuit court did not do so. Thank you. I'll rest my time for rebuttal.
You'll have about 2.5 minutes.
Yes, sir.
Good afternoon, may it please the court. I'm Terrell Arline. I represent Bay County. There's a lot of issues here. They're well briefed. Let me jump to what I think's the most important first, and that's that the lower court did not misconstrue the term contiguous. As you know, voluntary annexations under 171.044 have to be contiguous. And so then you have to look to the definition of contiguous, which is kind of a long drawn-out definition, 171.031. And it's the second sentence of the definition of contiguous that we're going to be struggling with here in this case, because this is the first case I know of where a local government's annexed across a body of water, and it's been challenged and been brought to court. And in this instance, it's North Bay in Bay County. And if you know the area, you can refer to the maps in the pleadings. North Bay is a bay of water that's on sort of the north side of the main boundaries of Lynn Haven, and the parcel that they annexed was on the other side of the bay. The parcel's a 22-acre parcel. They did annex, there's a road that goes from the mainland across the bay up towards the north up into Washington County called State Road 77, goes in a little town called Southport, unincorporated Southport. And the city had previously annexed some land on right there at the bridge. And so they had some municipal boundaries on the north side of the bay at the bridge, but they didn't annex adjacent to that piece. They jumped across the bay about 200 or 300 feet to the east of the current parcel that they had and annexed this 22-acre parcel, which is separated across the bay by about 3/4 of a mile. Judge Hess said that if North Bay had been nothing but pine trees and unincorporated, pine trees, there'd be no question this was a bad annexation because it's not contiguous to anything in the city municipal Lynn Haven's borders. But in this instance, it comes down to whether or not this body of water issue lets them annex across North Bay. So you've got a statutory construction case here. Is North Bay a minor geographical division? Does it matter? Is it a qualifying term, which we think it is? And then the second clause, if you read that second sentence of definition contiguous, it's got to be across the body of water, which we think is minor, and not prevent the territory sought to be annexed and the annexing municipality from becoming a unified whole. There's sort of two-part test, we think, there. Judge Hess ruled for us on both of those. He says North Bay is not a minor geographical division, and there's no testimony in the record to support the conclusion that there would be a unified whole. So
well,
let's focus on
see, on that particular point. What does unified whole mean?
Well, it's an essential requirement of law, so I think the court has some latitude to construe the term itself. And I think the court can construe the term to make sense, construe the term to further the purposes of the annexation statute. And here, what Judge Hess saw was an annexation across the body of water that was where there were no municipal roads connecting it to the city. You could drive up 77, but in order to get to the parcel, you had to cross unincorporated property and drive down county roads to get to it. He said it doesn't make sense that you would take sewer or police and fire on a barge across North Bay. So he said it would just be absurd to conclude that it was not a unified whole.
Why did he conclude that the roads or the bridge doesn't count? I mean, we're talking about, it says unified whole with respect to municipal services. And as I understand it, there was testimony that various municipal services could be provided by the city in a more effective way than the county.
There was that testimony, Your Honor, but the judge concluded that there was no testimony that it would operate as a unified whole. And I think concluded that in his mind it wasn't. And we submit that even if you find that error, you come back to this idea that the Bay, North Bay, is not a minor geographical division. It's a big body of water. And you've got to get over that qualifier in order to even get to the second portion. And we think that the terms, if you look at the way the definition of contiguous is set out, it uses semicolons to define various areas that you can annex across. And then when it says, gets to a body of water, it says a body of water, comma, water course, comma, or other minor geographical division of a similar nature. Well, why are those words there? They must mean something. Bay County is made up of 4 large bays, so, the opportunities for cities to annex across these bays can occur. Lynn Haven, in its brief and below, just ignored the terms minor geographical division. They just said, well, Judge, you can annex, board, you can annex across a body of water, period. We don't think that makes sense, basically on some statutory construction grounds. Number one, the terms minor geographical division are in the statute. You got to give them some meaning. You can't just ignore them. A water body can be any size. So we think there is a size limitation there.
When does it go when does it become minor? How large is a minor body of water?
I think it's dependent on a case-by-case situation. And in this instance, the judge said that 3/4 of a mile was not minor.
Is that for the judge to decide, or is that for the city commission to decide?
I think the judge can make a conclusion on what a term in a statute means that does not lead to an absurd result, and I think that's what he did here. He said that it would be absurd to say that you could annex across North Bay and that it was minor.
Well,
It would also, if you could annex across the bays, and regardless of size, you could have a situation like a spoke in a wheel, where you've got, if the hub was the various municipalities and the tire was the land and the inside was the various bays, you could annex here, Panama City here, and then have some county property, and then annex, Callaway here, and have, Lynn Haven annex over here, and it would just be chaotic.
Well,
and there was that testimony.
what about focusing on the unified whole concept? That is, the city could annex across a body of water so long as there was a way for the city services, municipal services, to be provided to the annexed property in a way that it would be a unified whole. That is, the citizens who lived in the annexed portion would have the equivalent access to municipal services as those within the old city limits.
Well, first of all,
Seems to me that's defining it in the context of the statute.
the judge has said that he reviewed the record, which on first tier he's entitled to do, and he didn't find any evidence on the unified whole, first response. The second thing is he thought it would be absurd in this set of facts to conclude that it was. The third thing is look at a case that talked about this issue. It was cited by the petitioners, and that's May versus Fort Myers, I think. It was a case where they annexed, Fort Myers annexed across a road, and the question came up about it being divided, and this provision of contiguous kicked in. They didn't talk about it whether it was minor or not, but they did talk about whether it could be served with services and whether people could interact. And in that case, the piece that they annexed fronted on the road that connected with the city, and here it doesn't do that. It's back in the woods, 200 or 300 feet from 77, and so case law tells you that that it shouldn't be interpreted that way. We don't believe that, and the legal conclusions of the expert that they are a unified whole is that all we need in these annexation cases is to have a planner get up and say, it's a unified whole. The judge construed the statute, I think, in an intelligent way and in a way that made sense for this particular annexation.
Well, I'll come back to Judge Hawk's question. Given the fact that the City Commission has knowledge about the nature of the city services that would be provided, that they're really experts in this area, why shouldn't the court systems give deference to those elected officials?
Okay, because the Supreme Court has told you that you're not to apply such a lenient burden of proof. They argue that the burden of proof is the fairly debatable standard because this is some sort of legislative decision. Well, first, this isn't a police power case. Annexation's different. Those fairly debatable standard and that deferential standard comes from old police power cases.
In fact, the city has to strictly comply with the annexation requirements.
Ayers versus Smith, and it's that simple. So, I think the reality is there's a war going on between cities and counties over turf in this state, and the annexation statute is sort of where this is played out. And it's not an unconsequential thing for counties. When cities annex property, they lose potential tax base. If it was a municipal service taxing unit, their police and fire service have to figure out whether they're going to serve the property or not. The rules and regulations of the county, their comprehensive plan, their regulations, their codes don't apply. I mean, there's a major shift in governance that happens when annexation occurs. And so you have an obligation, I think, to ensure that that system just doesn't become chaotic. And in Bay County, if you can annex across these bays, it will cause problems, and it has caused problems in this case. And I think that to strictly construe the statute means that you uphold Judge Hess's conclusion, and in this instance deny the writ.
While we are strictly construing statutes, would you go back to the first issue dealing with the standing of the county?
Yes, sir. Okay, Bay County has standing one of the simplest responses to this issue is Mr. Thuriak said that 171.081, which is the statutory cause of action, it tells you how you challenge annexations. He talked about that in the context of a voluntary annexation. But that section governs everything in the statute: voluntary annexations, involuntary annexations, and contractions. And so if you read this, where they talk about the party affected can challenge procedures and then or meet the requirements established herein as they apply to his or her property, that might be people whose property was involuntarily annexed, okay? And so you've got to think about the opportunities there. The other reason why their interpretation of this statute that the county doesn't have standing should be rejected is it's inconsistent with another portion of the statute. They said it was in harmony with the statute, but it's actually inconsistent with the definition of a party affected in 171.031. That says parties affected mean any persons or firms owning property in or residing in either a municipality proposing annexation or contraction, or owning property that is proposed for annexation to a municipality or any governmental unit with jurisdiction over the area. So the legislature in the definition clause set out two groups that had standing.
But 081, excuse me, Counsel, 081 doesn't say any party affected may file a petition. Are we simply not to pay attention to the language in the middle?
No, you're correct. It says any party affected who believes that he or she will suffer a material injury. They're telling you that that person has to own property. And we're
but you understand the problem is the second clause after the or to meet the requirements established for annexation or contraction as they apply to his or her property.
Right. That might be a person whose property was involuntarily annexed that would want to come in under this provision and challenge the annexation. Let me just point to this distinction between procedures. First of all, the term substantive doesn't even exist in this provision. That he says there's a difference between procedural and substantive in that provision. The second thing is the statute, if you go through and look for the word procedure and then look for the word substance, you're not going to find a major distinction in the Act between the two. The other response is the case law doesn't distinguish procedures and substance. Back to the May case. This is a quote from May. Further, under the voluntary annexation procedure set forth in Section 171.044, the only limitations prescribed are that the property be contiguous, reasonably compact, and that it not create enclaves. The court considered procedures to be this stuff about compactness and compatibility and all of that. And so I don't think there is that difference that if you found that counties could only challenge procedures, you wouldn't be furthering the remedy that should be provided by the statute. That's a remedial provision that should be read broadly. And it would create this bizarre situation where the only people that could challenge the involuntary annexation, the voluntary annexations, are the property owners who petitioned for it. You know, whether it was contiguous or not, that doesn't make sense, and you cannot adopt that kind of conclusion. Thank you.
3 points, Your Honors, maybe 4. The spokes in the wheel argument is basically the monster under the bed. If this court were to apply the test that we contend, the city contends, that you have to demonstrate unified whole, you have to demonstrate that the folks can socially and economically interact, then you don't have one city across the bay jumping across to another portion, a different city jumping across. You have to have the competent substantial evidence in the record to support that services could be provided by that city, that those residents will interact socially and economically.
But if the judge rejects that evidence, then you don't have competent substantial evidence, do you?
But it's not up to the judge to reject the evidence. In a case of this nature, the judge is supposed to simply look at whether or not there's any competent substantial evidence in the record, and there is competent substantial evidence in the record describing the services that were provided. If the expert had simply said it's unified whole, period, nothing else to support it, then the county would be here arguing that it was a conclusory statement, and they didn't provide any evidence in the record to support the conclusory statement. But instead, the city's expert witness set forth the services that are available from the city that the county doesn't provide, and then services that the city could provide more efficiently. So it is a different situation than saying that there was no evidence in the record. The circuit court judge inappropriately disregarded that evidence. Secondly, the unified whole argument versus the minor. City of Jacksonville has St. Johns River running through it. If we don't have the criteria and the standard that we're talking about, then we are going to go case by case by case. What's too big? We have no standards whatsoever. Adopting the construction that the city is arguing will provide guidance for the circuit courts and for the cities to understand what's too big. How do we know what's too big?
What is your too big?
Pardon?
What is too big in your standard?
I don't think there is a set standard, and if the legislature had wanted
So
one,
Key West could incorporate Port St. Joe.
only if Key West could demonstrate that they could provide services and that the residents would interact socially and economically. I think that's where that argument falls
Well, all they need is
apart.
someone to come in and say, we'll do a better library than Port St. Joe has, or
You're right. They could probably have somebody show up and say that, but you would be stating then that the city would act in bad faith and put up a sham expert witness or a sham planner to say that Key West could serve Port St. Joe. And not to mention the other side, the county, Monroe County, would be able to have somebody cross-examine, and then this court would serve a role, or actually the circuit court first would review that record to determine if there is any competent substantial evidence, not something that was just made out of whole cloth. My time is up. Thank you.
Thank you both.